Get a grip, then get a chip. Won't even trip. Though my cup was running over, I took only a sip. Stay hippin', then I'm hopping, I'm dropping. It won't be flopping, no shock. That whatever I'm selling, you will be copping. He was the strongest, though he was the one that cried. And he chose to kill his brother because he was from that side. And why? He chose this son because this one had pride. And instead of the narrow road, he chose the one that's wide. Sometimes the one that won was the one that tried. And the one who pulled the gun was the one that died. Looking good, a good look is the one that's fine. If I had to pick, fly would be the one that's mine. G-O-D, in the place to be. Attendee, Hard Knocks University. And since kindergarten, they've been hiding the knowledge. Homeboy is self-taught, never went to college. I'm brown skinned, I'm from Pelon. Raining alarm, then I remain cool and calm. Reading Psalm, fire like napalm bomb.
As we proceed to get what you need, we are in the information age on Do You Know Your Value page. It's the content creator with force like Darth Vader, back on the track with the facts and all that. One path is the way that I'm taking, getting closer to God in a tight situation. Tonight, we're going over the Annotated Glossary from Cracking the Code 3rd edition, starting from where we left off with the letter P. So without further ado, let us begin. Pledge: a deposit of personal property as security for a debt, delivery of goods by a debtor to a creditor until the debt is repaid, generally defined as a lien or contract that calls for the transfer of personal property only as security. The pledger can pledge intangible as well as tangible personal property as long as it is capable of delivery, and it can confer ownership rights upon the person to whom delivery is made. Barron's 3rd. See note. Note: the bankrupt U.S. government pledged your body, labor, and property as collateral for a loan of credit. Federal Reserve notes using your birth certificate, negotiable instrument, document title as the security for the loan. Ponzi scheme: a fraudulent investment scheme in which money contributed by later investors generates artificially high dividends for the original investors, whose example attracts even larger investments. Money from the new investors is used directly to repay or pay interest to old investors, usually without any operation or revenue producing activity other than the continual raising of new funds. This scheme takes from Charles Ponzi, who in the late 1920s was convicted for fraudulent schemes he conducted in Boston. Black's 7th. See the cursive code suretyship in part 1 of this manual. Positive law: law actually and specifically enacted or adopted by proper authority for the government of an organized jural society. Black's 6th. Possessory: relating to possession, founded on possession, contemplating or claiming possession. Black's 1st. Possessory lien: a lien allowing the creditor to keep possession of the encumbered property until the debt is satisfied. Black's 7th. See UCC 9333, priority of certain liens arising by operation of law in this glossary. Note: the new security agreement in this manual evidences a possessory lien, common law lien regarding certain collateral, giving a secure party right of possession of every such item of a debtor's property until the obligation is satisfied. The possessory lien has priority over a security interest in goods. Post liminium: a fiction of the civil law by which persons or things taken by the enemy were restored to their former status on coming again under the power of the nation to which they formerly belonged. Bouvier 8th. Compare post limine. Post limine: the right of post limine, says Vattel, is that in virtue of which persons and things taken by the enemy are restored to their former state on coming actually into the power of the nation to which they belong. Post limine is defined to be the principle of the law of nations under which property, if taken by the enemy in time of war, is restored to its former state upon coming again under the power of the nation to which it formerly belonged. That's volume 33. Compare post liminium. Preferred: possessing or accorded a priority, advantage, or privilege, generally denoting a prior or superior claim or right of payment as against another thing of the same kind or class. Black's 4th. See stock. Presentment: in the second sense, a formal written accusation returned by a grand jury on its own initiative without a prosecutor's previous indictment request. A grand jury has only two functions: either to indict or return a no bill, The Constitution speaks also of a presentment, but this is a term with a distinct historical meaning now not well understood. Historically, presentment was the process by which a grand jury initiated an independent investigation and asked that a charge be drawn to cover the facts should they constitute a crime. With the United States attorneys now always available to advise grand juries, proceeding by presentment is now an outmoded practice. Number 1, Charles Allen Wright, Federal Practice and Procedure, subsection 110 at 459, 3rd edition, 1999. In third sense, the formal production of a negotiable instrument for acceptance or payment. Presentment and dishonor occur, for instance, when the holder of a check attempts to cash it at the drawee bank, but payment is refused because the drawer lacks sufficient funds on deposit. The demand for payment is the presentment. The bank's refusal to pay is dishonor. In the second sense, James J. White and Robert S. Summers, Uniform Commercial Code, subsection 16-8, at 100, 4th edition, 1995, Black 7th, presentment means a demand made by or on behalf of a person entitled to enforce an instrument. 1, to pay the instrument made to the drawee, or a party obliged to pay the instrument, or in the case of a note or accepted draft payable at a bank, to the bank, or 2, to accept a draft made to the drawee. UCC 3501A may be made by any commercially reasonable means, including oral, written, or electronic communication, is effective when the demand for payment or acceptance is received by the person to whom presentment is made. UCC 3501-1, the production of a negotiable instrument, bill of exchange to the drawee for his acceptance, or to the drawer or acceptor for payment, or of a promissory note to the party liable for payment of the same. Presentment is the demand for acceptance or payment made upon the maker, acceptor, drawee, or other payor by or on behalf of the holder. UCC 35041, Black 6. See note, summary proceeding. Notice that the identical terms are used in the definition when speaking both of criminal matters and financial commercial matters. In criminal matters, a bill called a true bill is issued by the grand jury. A bill is a list of charges, both criminally and financially. A true bill is a list of charges that is sworn, true, correct, and complete. Affidavit. In financial matters, a presentment can only be one of the following. 1, a demand for payment of a negotiable instrument, or 2, a demand for acceptance of responsibility for payment / performance regarding a negotiable instrument. Presumptions. Nature. Except as otherwise provided in section 1202, the presumptions established by this code are presumptions affecting the burden of producing evidence. UCC 1210. Presumption. A presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. A presumption is either conclusive or rebuttable. Every rebuttable presumption is either A, a presumption affecting the burden of producing evidence, or B, a presumption affecting the burden of proof. Blacks 6. A disputable presumption, called also an inconclusive or rebuttable presumption, is an inference of law which holds good until it is invalidated by proof or stronger presumption. Blacks 4. See note, disputable presumption, rebuttable presumption, legal fiction. Note, regarding ownership of your trade name, a presumption of ownership was made and title thereto. Birth certificate was taken without knowledge and consent of both your mother and you. Such presumption is nullified via the publication of the copyright notice under common law and is further amplified with the filing of a UCC financing statement. Priority. Precedence going before. A legal preference or precedence when two persons have similar rights in respect of the same subject matter, but one is entitled to exercise his right to the exclusion of the other, he is said to have priority. Blacks 4th. Private bank, an unincorporated banking institution owned by an individual or partnership and depending on state statutes, subject to or free from state regulation. Blacks 1st. See banker. Private banker. A private banker is one who conducts the business of banking without incorporation and without any special privilege or authority of law. Perkins v. Smith, 116 New York, 441. People versus Doty, 80 New York, 225. A private banker may, when not prohibited by law, conduct the business of banking and may make such lawful contracts with his dealers in relation thereto, as to receiving and the repayment of money as may be mutually agreed upon between the parties. A private banker then is one who conducts the business of banking without incorporation or fixed capital stock invested, which is by law required of all duly incorporated banks, except in mutual savings banks, which under the law as enacted by some of the states may become incorporations for the purpose of doing a savings bank business without capital. Meiji on Banks and Banking, a treatise on the law of national and state banks, 1906. Note, per 31 United States Code 5312 A2C, every private individual is a financial institution and a private banker. In Bank of Augusta versus Earl, the court ruled a private individual has as much privilege as banks. Prize, in admiralty law, a vessel or cargo belonging to one or two belligerent powers apprehended or forcibly captured at sea by a war vessel or privateer of the other belligerent and claimed as enemy's property and therefore liable to appropriation and condemnation under the laws of war. Blacks first. See prize law, booty, vice admiralty, courts. Note, prize on land is called booty. See booty. Prize law, the system of law and rules, the system of laws and rules applicable to the capture of prize at sea, its condemnation, rights of the captors, distribution of the proceeds, etc. Blacks first. See vice admiralty, courts, booty. Proceeds. Proceeds except as used in subdivision B of section 9609 means any of the following property. A, whatever is acquired upon the sale, lease, license, exchange, or other disposition of collateral. B, whatever is collected on or distributed on account of collateral. C, rights arising out of collateral. D, to the extent of the value of the collateral, claims arising out of a loss, nonconformity, or interference with the use of, defects, or infringement of rights in or damage to the collateral. E, to the extent of the value of the collateral and to the extent payable to the debtor or the secure party, insurance payable by reason of the loss or nonconformity of defects or infringement of rights in or damage to the collateral. UCC 9102 A64. Anything that is used to guarantee the payment of a loan or the fulfillment of some other obligation. Promise. Promise means a written undertaking to pay money signed by the person undertaking to pay. An acknowledgement of an obligation by the obligor is not a promise unless the obligor also undertakes to pay the obligation. UCC 31039. Promissory note. Promissory note means an instrument that evidences a promise to pay a monetary obligation, does not evidence an order to pay, and does not contain an acknowledgement by a bank that the bank has received for deposit a sum of money or funds. UCC 9102 A65. A note, the kind of negotiable instrument wherein the maker agrees, promises to pay a sum certain at a definite time. Barron's third. See note. When banks when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction accounts. Modern Money Mechanics, page 6, Federal Reserve Bank of Chicago, 1992. Note, promissory note is synonymous with note. The last section of the first definition above tacitly acknowledges that a borrower's promissory note constitutes funds/money. Banks do not loan substance. Per banking regulations and generally accepted accounting principles, banks are forbidden from loaning the bank's assets and likewise the assets of the bank's depositors. As confirmed in the above excerpt from Modern Money Mechanics, the signed promissory note constitutes the sole source of the funds that are loaned for the benefit of the borrower. No substance is loaned. The so-called transaction account referenced in the above excerpt from Modern Money Mechanics goes on the bank's books exactly as a demand deposit, checking, savings, passbook time account would. The borrower, customer, is actually the lender and creditor of the bank. The bank is actually the borrower and debtor of the customer. The bank issues a pretend loan, which is actually the borrower's depositor's own funds taken from the transaction account created upon the borrower's customer's execution of the promissory note and the bank's subsequent deposit of the promissory note, the money, into the account. See House Joint Resolution 192 of June 5th, 1933. Proper. A, of a name, noun, or adjective designating a particular person or thing, written in English with an initial capital letter, like John, Chicago, Monday, American, and grammar used to designate a specific individual, place, etc. Donald, Rover, Boston, etc. are proper nouns written with an initial capital letter. Webster's New 20th Century Dictionary of the English Language, unabridged, second edition, 1975. Note, a true name has an initial capital letter only. There is no provision in the rules of English grammar for proper nouns to be written any other way, including in all capital letters format. An all capital letters name is a legal artifice existing only by force of or in contemplation of law. See capital letter, all capital letters written, artificial. Propria persona. See in propria persona. Proposal. Proposal means a record authenticated by a secure party that includes the terms of which the secure party is willing to accept collateral in full or partial satisfaction of the obligation it secures pursuant to sections 9620, 9621, and 9622. UCC 9102A66. Protest. A notarial act being a formal statement in writing made by a notary under his seal of office at the request of a holder of a bill or note, in which such bill or note is described and it is declared that the same was on a certain date presented for payment or acceptance, as the case may be, and that such payment or acceptance was refused, and stating the reasons, if any, given for such refusal, whereupon the notary protests against all parties to such instrument and declares that they will be held responsible for all loss or damage arising from its dishonor. Blacks first. Prove. Prove with respect to a fact means to meet the burden of establishing the fact. Subdivision A of Section 1201, UCC 3103, 10. Public, pertaining to a state, nation, or whole community, proceeding from, relating to, or affecting the whole body of people or an entire community, open to all. Notorious, common to all or many. General, open to common use, belonging to the people at large, relating to or affecting the whole people of a state, nation, or community, not limited or restricted to any particular class of the community. Black 6. The vast multitude, which includes the ignorant, the unthinking, and the credulous, who in making a purchase do not stop to analyze but are governed by general appearance and general impressions. From Ballantyne's Law Dictionary. Public corporation. Public corporations are those which are exclusively instruments of the public interest. Bouvier 8. An artificial person created for the administration of public affairs. Unlike a private corporation, it has no protection against legislative acts, altering or even repealing its charter. Instrumentality is created by state, formed and owned by it in public interest, supported in whole or in part by public funds, and governed by managers deriving their authority from the state. Blacks 6. See note. Public debt. That which is due or owing by the government. Bouvier's 6. Public enemy. This word, used in the singular number, designates a nation at war with the United States and includes every member of such action. To make a public enemy, the government of the foreign country must be at war with the United States. For a mob, howsoever numerous it may be, or robbers, whoever they may be, are never considered as a public enemy. Bouvier's 6. See note. Note, declared public enemies of the United States are by definition citizens of a foreign country/nation. Public law, that branch or department of law which is concerned with the state in its political and sovereign capacity, including constitutional and administrative law, and with the definition, regulation, and enforcement of rights in cases where the state is regarded as the subject of the right or object of the duty, including criminal law and criminal procedure, and the law of the state considered in its quasi-private personality, in other words, as capable of holding and exercising rights or acquiring or dealing with property in the character of an individual. Blacks first. See note. Note is meant to designate a government associated with a collective body politic. It is a fictitious entity and therefore cannot be sovereign. And that's a case called Juliet versus Green from 1884. And the Supreme Court states Congress can exercise no power by virtue of any supposed inherent sovereignty in the general government. Indeed, it may be doubted whether the power can be correctly said to appertain to sovereignty in any proper sense as an attribute of an independent political community. The power to commit violence, perpetrate injustice, take private property by force without compensation to the owner, and compel the receipt of promises to pay in place of money may be exercised, as it often has been, by irresponsible authority, but it cannot be considered as belonging to a government founded upon law. But be that as it may, there is no such thing as a power of inherent sovereignty in the government of the United States. The fact that black states, the state in its sovereign capacity, tacitly confirms that every man and woman is a state, as only a real being with free will can be sovereign. Public policy, in the first sense, broadly principles and standards regarded by the legislator or the courts as being of fundamental concern to the state and the whole of society. Courts sometimes use the term to justify their decisions, as when declaring a contract void because it is contrary to public policy. The second sense, more narrowly, the principle that a person should not do anything that would tend to injure the public at large. Blacks 7th. Community common sense and common conscience extended and applied throughout the state to matter of public morals, health, safety, welfare, and the like. It is that general and well settled public opinion relating to man's plain, palpable duty to his fellow man, having due regard to all circumstances of each particular relation and situation. Black 6. Public policy is manifested by public acts, legislative and judicial, and not by private opinion, however eminent. It is said to be determined from legislative declarations or, in their absence, from judicial decisions. Bouvier's 8th. See note, public law. Note, a general concept taken in the whole of society considered as a single, abstract, collective entity as contrasted with the same benevolent principles applied on behalf of individual members of society. The public cannot be harmed, only individual men and women can be harmed. Since Erie River versus Tompkins in 1938, shortly after the declared bankruptcy of the United States government, we have had only public policy, not public law. The above definition from Black's 6, 1990 cannot be found in Black's 4th from 1957, which was printed at the time the subject of public policy was being implemented and replacing public law. In other words, the switch has taken place and the institution of public policy is now entrenched. Example given. As well as the UCLA School of Law, there is also a UCLA School of Public Policy and Social Research. Look around and see for yourself. Public property, that which is dedicated to the use of the public and or that over which the state has dominion and control. Thus, the term may be used either to describe the use to which the property is put or to describe the character of its ownership. Barron's 3rd. Public vessel, one owned and used by a nation or one owned or used by a nation or government for its public service, whether in its navy, its revenue service, or otherwise. Black's 6. See note. Note, your corporately colored trade name may be construed as a vessel, a public vessel, and is used by the U.S. government in its revenue service and otherwise. See vessel. Purchase. Purchase includes taken by sale, discount, negotiation, mortgage, pledge, lien, issue or reissue, gift, or any other voluntary transaction, creating an interest in property. UCC 120132. The term purchaser includes any contract to purchase or otherwise acquire. Securities Exchange Act 3. See note. Purchase money security interest. A security interest which is created when a buyer uses the money of the lender to make the purchase and immediately gives to the lender a security interest. UCC 9107. Compare security interest. See note. Note, when you borrow to purchase a new automobile, the purchase money for the car comes from the lending bank. The lending bank is listed on the certificate of title as lien holder. This is a designation of the lending bank's purchase money security interest in the car. The funny thing is, however, when a loan takes place at a Federal Reserve member bank, the money of the lender does not come from the lender bank. It comes from the borrower. Banks do not loan their own money. In other words, no account belonging to the bank is debited in the loan transaction. The banker does a banker's acceptance of the borrower's promissory note, cash, and loans it back to the borrower at interest. What banks do when they make loans is to accept promissory notes in exchange for credits to the borrower's transaction accounts. Modern Money Mechanics, page 6, Federal Reserve Bank of Chicago, 1992. Ransom. The compensation required to avoid bodily punishment or to free oneself from an undesirable state or condition. The term kofa is related to the Akkadian kaparu, to wipe off, or kapuru, to expiate. The substitution for a penal sum for corporal punishment was widespread in the ancient world. Thus, the Hittite code provides for fixed damages for bodily harm, and the Bodun, too, allowed for ransom as an alternative to blood vengeance, except in the case of murder. The Israelites followed this practice too, though fixed sums do not seem to have existed in earlier times. Instead, the principle of measure for measure was employed, together with specific standards from determining the compensation. Later, set amounts were established, such as the redemption fees for those consecrated to Yahweh, to be distinguished from kofa in the sense of ransom, which is paid to an aggrieved party, is kofa in the sense of bribe, which is paid to a judge in the hope of influencing his decision. See also captives, ransoming of Encyclopedia Judaicae, 1972, compare redemption. Real party in interest. The person who will be entitled to benefits of a court action if successful, one who is actually and substantially interested in the subject matter as opposed to one who has only a nominal, formal, or technical interest in or connection with it. Barron's 3rd, see real party of interest. Real party of interest, see note. Note, this term is not defined in law dictionaries, just as Federal Reserve notes is not defined. Big Brother's operation cannot withstand the light of day, and so must remain in the shadows. The real parties of interest are unknown. A real party interest, defined directly above, is merely an intermediate link in the chain. The actual boss is the real party of interest. Rebuttable presumption. An ordinary presumption which must, as a matter of law, be made when certain facts have been proved, and which is thus said to establish prima facie conclusion, and may be rebutted or overcome through the introduction of contrary evidence. But if it is not, it becomes conclusive. After rebutting evidence is introduced under prevailing doctrine, the competing facts are weighed on their own merits, without further reference to the presumption. Barron's third. See also disputable presumption. Presumption, legal fiction. Record or record, except as used in for record, record of legal title, and record owner, means information that is inscribed on a tangible medium or which is stored in an electronic or other medium and is retrievable in perceivable form. UCC 9102A69. Redeem, to buy, variant of amir, to purchase, to buy back, to free property or article from mortgage or pledge by paying the debt for which it stood as security, to repurchase in a literal sense, as to redeem one's land from a tax sale. It implies the existence of a debt and means to rid property of that encumbrance. Redemption, salvation from the states or circumstances that destroy the value of human existence or human existence itself. The word redeemer and its related terms redeem and redemption appear in the Bible some 130 times and are derived from two Hebrew roots. Though used to describe divine activity as well, they arose in ordinary human affairs, and it is in this context in which they must first be understood. It is the more general of the two, with cognates of relating meaning Akkadian, Arabic, and Ethiopic. It belongs to the domain of commercial law and refers to the payment of an equivalent for which is released or secured. The verb PDH, unlike GL, indicates nothing about the relation of the agent to the object of redemption, which in the Bible is always a person or another living being. Its usage does not differ in cultic activity from that of a normal commercial transaction. In both cases, a person or an animal is released in return for money or an acceptable replacement. And then you got biblical verses, which have been in the last two definitions. So GI is more restricted in usage and does not appear to have cognates in other Semitic languages. It is connected with family law and reflects the Israelite conception of the importance of preserving the solidarity of the clan. The goal, redeemer, is the next of kin who acts to maintain the vitality of his extended family group by preventing any breaches from occurring in it. Thus he acquires the alienated property of his kinsmen, or purchases, and when it is in danger of being lost to a stranger. When the Bible uses both padah and gal for redemption, the Talmud applies padah to ransom and gal to redemption. See note, compare ransom, see payment. Cognate, a person or thing related in origin. Note, per Encyclopedia Judiciae, the subject of redemption belongs in the domain of commercial law, has to do with payment of an equivalent for what is released or secured, is essentially commercial in nature, even if cultic, religious, sacred, and wherein a person or animal is released in return for money or on a substitute. Register, to record formally and exactly, to enroll, to enter precisely in a list, or the likes. Blacks 6. See note, refi. Note, from Latin regere, to rule, rex, king. Essentially, to register is to kingify, or to rulify oneself or one's property. In other words, to submit and place one's property in a position to be subjected, owned, controlled, regulated, thus facilitating taxation. And it came to pass in those days that there went out a decree from Caesar Augustus that all the world should be taxed. And this is Luke 2:1, Holy Bible, King James Version. Registration is the necessary step before taxation. Register, denoting cattle, horses, dogs, etc., having pedigrees verified and filed by authorized associations of breeders. Webster's. Reef, a robbery. Colwell Blacksforth, see refication, see refi. Reification, the embodiment of a right to the payment of money in an instrument, so that transfer of the instrument transfers also the right. The term can also refer generally to the embodiment of any other property in a writing, which writing represents the property. Blacks 6. See reef, reefer. Note, what was once known as simple highway robbery, a reef, is now known as reefication, or the registration of the property, in the juristic trade name of your strawman, of course. Consulting the words reef and reefer, one can see that governments have given itself license to overtly rob and steal from its subjects. Trade names under the euphemism reification, another term for registration, per UCC 9302. Registration constitutes surrender of legal title to the property registered, an act which precludes the necessity for the register agent for the secured party government to file a UCC financing statement against the registrant debtor to perfect the security interest in the property. Refi, to convert into or regard as a concrete thing. To refi, an abstract concept. See note, reef, note at register. Note, this term is essentially identical in concept with the word register. Literally translated means to kingify or rulify oneself or one's property. The abstract concept that someone else can claim your body, labor, property, and wealth is converted into a reality when you, your property, is registered, a phenomenon known as a reef or robbery. The fact of registration obviates the need for the register to file a financing statement against the registrant debtor regarding the property in question. And at this moment in time, we're going to pause or stop right here. Like, share, leave a comment, subscribe. And this is definitely getting very, very interesting. The further along we go with the definitions, it's going to get more interesting. And you definitely have to do your own research regarding this topic and these definitions and everything else that you see. And with that, I'm going to say be peaceful, stay blessed, pay to pass God's tests. I'm going to talk with you guys